SJC-12120, Joan E. Oggiani v. Chief Justice of the Trial Court, and others.
Ms. Oggiani, good afternoon.
Good afternoon. If it may please the court, thank you. My name is Joan Oggiani. I'm the appellant. I'm self-represented. I want to thank you for the opportunity to speak. And I'd like permission to read a short prepared statement. Certain facts relating to my employment, the deputy register position, and my demotion are set forth in my petition. I also direct your attention to my brief, where I have attached a detailed statement of my employment history and duties list. Allow me to begin, please, by reading the very first sentence of Mass General Laws, Chapter 211, Section 3. The Supreme Judicial Court shall have general superintendents of all courts of inferior jurisdiction to correct and prevent errors and abuses therein, if no other remedy is expressly provided. I respectfully ask that this honorable court correct an error and an abuse made in the removal of my deputy assistant register position. I have no other remedy available to me. I was 20 years of age in February 1980 when I began my employment with the Berkshire Division of the Probate and Family Court. I am a high school graduate who earned a paralegal certificate. I worked while in high school and for 2 years as a secretary in a Great Barrington, Massachusetts law office. The presiding justice in 1980 was Andrea F. Nusiforo. He had been appointed to the bench in 1973 by Governor Francis Sargent. Prior to his appointment, he served two-year terms as a state senator, and before that had a private law practice in Pittsfield, Massachusetts with his uncle, John Alberti. My job was clerical. I took dictation using the Gregg method of shorthand and typed on an IBM Selectric typewriter. It was my first experience working for and with the public. By July 1980, Judge Nusiforo had already singled me out and was beginning to dictate decisions to me after he had heard them in the courtroom. Shortly thereafter, I began clerking with him in the courtroom. In order to give some background into the acquisition and appointment of the Deputy Assistant Register for the Berkshire Division, I believe it is relevant to convey to you something of Judge Nusiforo's qualities. He brought intelligence and diligence to every case before him. One case stands out about which he felt very strongly. This was Heinrich versus Silvernail, a will contest about undue influence. The site is 23 Mass Appeals Court 218, the year 1986. I sat in on the several days of trial with him and typed the statement of the case for him, as with most of his decisions, doing many revisions until it was the way he wanted. He ultimately got reversed, but his statement of the case is a wonderful example of how much he delved into a particular case, the traits he saw in people, and his ability to write a clear, concise, compassionate, and convincing decision. Judge Nusiforo was an excellent judge, a kind person, and perhaps unusually for a former politician, a modest, unassuming man. He had a gift for making everyone, not just me, feel valued. In the early 1990s, he began telling me I should go to law school. While this was flattering, he meant it. So it is with confidence that I can state that Judge Nusiforo would not make any appointment or promotion lightly. He did not necessarily relish the thought of returning to the legislature after many years gone to ask for something. In fact, his favorite saying with regard to soliciting favors was left over from his Senate days, and it was with a certain wry humor that he would say, "What have you done for me lately?" This information is relevant to the Deputy Assistant Register acquisition because It was unique in that I did not have a passive role in its procuring. Of course, he had all the influence, but we did it together. I typed letters to representatives on his behalf. In this first part of a two-part process, the judge made it a civics lesson, explaining the process of writing and filing a bill. He told me he had served on a committee for writing laws. He loved language. And the course a bill takes as it wends its way through the House and Senate. After many months of preparation, the judge made a final telephone call through to the Senate floor directly to the Speaker. The bill was thereafter signed. He wanted me to fully appreciate the process involved, a combination of know-how and political savvy. He was proud of the democratic process. What is considered in a candidate for an appointment of this type, I don't know the answer. I do know what went into the appointment designated to me in the second part of this process because of the integrity of the person making the designation, the judge, and my own abilities and qualifications. It was not a token appointment. To have had it removed so casually and for sham reasons was wrong. I would like to point out that there is nothing in my personnel file which would remotely warrant a demotion, a further reason this removal was so arbitrary. In sum, from the beginning, this case was about fairness. How is this removal fair? I have been harmed. One gets a reputation when one has worked hard and well for many years at a job, a reputation relied upon by lawyers and judges and colleagues. My reputation has been damaged. There's now a permanent letter in my personnel file. There is a demotion. Standing alone or together, any or all of these factors more than likely ensures that I would have great difficulty receiving any upgrade in the future. There are feelings of low self-worth which go hand in hand with a demotion and which I feel to this day. I have also been harmed financially. There is no requirement that the register give a reason for removal. However, by the fact alone that Mass General Laws, Chapter 217, Section 29D, states that an appointment or removal must be approved by the Chief Justice, demonstrates that the lawmakers wanted to create a safety valve whereby any appointment or removal was not made without basis or with capriciousness. I followed each and every order given by the register, assistant registers, and judges, and carried out all of my duties in an excellent manner. When I needed to perform in management's stead, I did so. I was a leader in the office. Not only was my demotion arbitrary and capricious, it was wrong, unfair, and unjust. My petition under General Laws, Chapter 211, Section 3, seeks to right this wrong. I ask this honorable court to invoke its power under this statute and grant me the relief I seek in my petition and outlined in my brief. Thank you.
Thank you. Ms. Benedon?
Good afternoon, Your Honors. May it please the court, Assistant Attorney General Carrie Benedon for the court defendants. Your Honors, this court should affirm the single justice's denial of Ms. Oggiani's petition for extraordinary relief, challenging the removal of her Deputy Assistant Register designation. The plain language of the statute, Chapter 217, Section 29D, provides that the register may, with the approval of the Chief Justice of the Probate Court, remove a Deputy Assistant Register. There is no requirement in the statute that the removal of the designation be only for good cause. There is no arbitrary and capriciousness standard. There also is no provision in the statute that requires or provides for a hearing before an individual's designation as a Deputy Assistant Register may be removed. This is in contrast to many other statutory positions where, or designations where the legislature has expressly provided for a review process for a hearing, has established a just cause removal standard, or stated that removal may not be for arbitrary or capricious reasons.
Has the register appointed somebody else to this position?
I do not know the answer to that question. It's very reasonable that the legislature may have decided not to allow for a hearing and not to require any particular substantive standard before this designation may be removed. It's critical to note that the Deputy Assistant Register designation is not a full position of employment. It's an add-on, and yes, it carries with it an additional stipend. But it's very possible that the legislature did not want to subject this designation to the full review procedure set forth in Chapter 30A, the Administrative Procedures Act, not to require the
Excuse me,
justice.
but the decision could be arbitrary and capricious, and that would be okay?
The statute does not prohibit a decision for arbitrary and capricious reasons. I think that no action of government should be arbitrary or capricious. But the question is whether there is a requirement that facts be set forth that support the removal and whether there be a hearing. The legislature clearly did not intend that the removal had to be supported by findings supported by substantial evidence. If there were no reason given at all by the register to the justice seeking removal, I think that would be acceptable. The justice would then have the ability, if she wished, to request information.
Do you mean the Chief Justice?
Yes, I'm sorry, the Chief Justice who needs to approve the removal.
Is there any reason given here?
Yes,
And the reason was, remind me?
The reason was that although the appellant seemed to be a fine employee, she did not seem to demonstrate initiative beyond the competent performance of her duties, and that the register expected the person who was holding this designation to take initiative and to be more of a leader for the younger employees. So it was not a suggestion that she did not adequately perform her regular job, which is as a judicial secretary, a position that she continues to hold. It was simply that he didn't feel that she met the expectations for this additional designation.
Did the job change at some point? I mean, she was doing it for all these years. What happened to make her so unsatisfactory so suddenly?
Well, first, I would suggest that it's not necessarily the case that she suddenly was so unsatisfactory, and there is no requirement that she can only be removed, that this designation may only be removed if she was suddenly so unsatisfactory. It is the case that before 2006, and in fact, when the appellant was first appointed to this position, the appointment was made by the first justice of the probate court. Since the amendment to the statute in 2006, the appointment is made by the register. And so it may be the case that the register has different expectations of the position than the first justice had. It also may be that the register simply was looking to go in a different direction with the position. Because there is no just cause requirement or standards that an employee can only be removed in accordance with a specific procedure, it would have been completely appropriate if, let's say, for example, hypothetically, the register said, I think that it would be good for the office if I rotated this position around every year or every 2 years. I don't know that that's what happened in this case, but the register might say, I think it would be good if everybody had an opportunity to learn a little bit more and therefore give each person the opportunity for 1 or 2 years. I suggest that would be completely appropriate and that nothing in the statute would prohibit that sort of a decision. So we don't know who has been replaced. I don't know who has been replaced into this designation, if anybody, but I urge the court to read the statute as written and to find that there is a lot of discretion here by the register, subject only to the approval of the Chief Justice, and that absent an allegation that the removal was for some illegal reason, some discriminatory reason, there really is nothing more that needs to be looked at here.
Does this job exist except in a Berkshire probate court?
It does. It exists, I believe, in every county.
Yeah.
And by statute, there are different statutes. So in 217, Section 29D through 29J, I believe it is, each statute corresponds to a specific county. Some counties have more than one of these, and the amount of the compensation is different in different counties. I think in some counties it's as high as $15,000. In Berkshire, it's $6,000. And the duties and responsibilities of the Deputy Assistant Register also are set forth by statute, and they are the same duties as the Assistant Register. And the duties of the Assistant Register are also spelled out by statute in Chapter 217, Section 27. They are things like authenticating papers in the absence of the register, completing and attesting records. So there are specific statutory duties and authorities of the Assistant Register and therefore also the Deputy Assistant Register. And so it simply may be the case that the Register thought it appropriate to appoint somebody who worked more in the Register's office as opposed to on the court side of things to hold this role. We don't know, again, who has been appointed to this designation, but there could be a lot of reasons. Now, I do note that the decision of the single justice that denied this 211-3 petition denied it without prejudice and specified that he wasn't passing on the question of the availability of other relief. If the appellant in this case believed that removal was inappropriate, for example, for a discriminatory reason, there are other avenues for seeking that relief, such as a complaint of discrimination. I don't think there's been any allegation in this case that was the case. She also acknowledges that there is no opportunity to grieve this position because this designation is different than a standard employment position and therefore isn't subject to the union collective bargaining agreement. But I do believe it's significant that Justice Spina did leave those other things open, and I think although his decision denying this petition was very short, he was suggesting that there is no avenue for review of this removal here. There's no requirement that a hearing have been held, and there's no opportunity for review of that decision. But if there is an allegation that something else inappropriate was going on, then maybe there is a different avenue of review. But it's clear by the statute that it isn't here. There was no requirement that any particular showing be made, and there was no requirement that the Chief Justice hold a hearing before approving the removal. For these reasons, Your Honor, I urge the court to affirm the single justice's denial of Ms. Oggiani's petition for extraordinary relief. Thank you.
Thank you.